Hello, my name is Evan Wright. I'm a solicitor and partner at JMW Solicitors, the Business Crime and Regulation Unit. And we've been discussing a number of topics raised by our corporate and individual clients, particularly in the areas of deferred prosecution agreements. And I thought it'd be an idea to ask Mr. Nick Johnson, a barrister from Exchange Chambers, to come along and discuss some of the typical issues and questions that we are asked both at the investigation stage, potential prosecution stage, where deferred prosecution agreements might arise. Nick has represented in the Johnson & Johnson case in the US. He has represented in fraud and anti-bribery cases both in the UK and in other countries, and is well placed to advise on these points. This is an introductory video. If you have issues arising out of it, then by all means get in touch and we'll do our best to assist. Thank you for watching. Mr. Nick Johnson, thank you again for coming.
Thank you.
In an earlier piece, we were discussing deferred prosecution agreements, and we were discussing what a deferred prosecution is.
Yes.
We were discussing how many we might see over the coming while, because this is a very new concept in the UK, albeit a relatively mature concept in the US. And you give a general description of what to expect. But I'd like to focus on one of the most important questions that I know a corporate client would want to discuss upon asking for advice in a range of scenarios where a deferred prosecution agreement might become an issue, and that's the issue of costs. And I don't just mean the costs of the investigation, what financial penalty a corporate client might have to pay at the end of that process, but also things like the cost of shareholder actions, the cost of not being able to access contracts at the end of that process. So this video can't cover all of that in a vast amount of detail. But are those the kind of things that a client needs to be advised on from the very beginning? And what other kind of costs issues would you need to discuss?
Well, advice about costs at an early stage and action as a result is absolutely vital, because these things can be costly both directly and indirectly in the ways that you describe. It's a rather controversial area if you think about it, because what are we talking about here? You're deferring a prosecution, in other words, alleged criminal behaviour, for the payment of money, effectively. That would be a sort of cynical view of this, and it could be said to be reducing criminal behaviour to a form of taxation. But there are many more other sides to this as well. It's aimed at bringing about a change of culture. It's aimed at bringing about corporate compliance, internal controls, to avoid these things in the first place. And then in terms of cost, once a potential investigation is underway, spending that money, incurring those costs at the beginning or even before it took place, is really the way to saving cost further down the line. And so if you have those internal controls, if you have a Bribery Act compliance procedure, you're less likely to face this. If you do face this, having very early engagement with the authorities is absolutely key. Obviously it's pre-charge, but to try to assist them in order that they do approach you as a candidate for a deferred prosecution agreement, and then to have all your internal investigations completed and presented to them in an effort to assist in avoiding a prosecution. If you bury your head in the sand, if you try to avoid areas that are obviously of concern to you, you're going to get the direct costs and the knock-on effects in the ways that you describe. The way in which you do business can be curtailed. There may be civil actions as a result. You may get parallel enforcement by the Financial Conduct Authority or similar authorities, for example. It'll have an effect on your reputation, and then you may have shareholder actions, as you say, and other types of litigation. So yes, it's going to cost you something, but spend the money earlier on preventative and early engagement measures, and you'll reduce your costs and keep them to a minimum.
Well, just following on from that, the SFO in particular recently talked about the way in which corporations investigate themselves when they are thinking about reporting internal fraud themselves, self-reporting as it's called. And although it wasn't directly said, there seemed to be and I shouldn't really call this a complaint, but there was certainly a concern that some corporations will investigate themselves, will gather evidence in a particular way, and then will present that to the SFO in a way in which is supposed to encourage the SFO to act in a particular way and steer them down a particular course. And they don't appear to like that very much. And in some cases, I'm sure the internal investigations are presented in a very coherent and admissible way. But one wonders, because this is a new concept, that the SFO want to set down a marker now and say, if you are thinking of self-reporting and if you are thinking of investigating yourself or your agents, for instance, come to us early. We will provide you with some guidance. We will provide you with some parameters and measures so that when you do this, you can present us with a report we can actually use.
Indeed.
And I suppose the degree to which you actually engage with the SFO from day one is going to be quite critical, and some corporations will be better at that than others.
Yes.
But you're probably going to say now that yes, advice at that early point is extremely important.
Well, yes, you can see from the points that you raised that tactically this is a complex area, and early engagement is important, and a credible internal investigation is absolutely vital. It's not just a lawyer talking here. This is the subject of detailed guidance the SFO have produced, a code of practice in relation to deferred prosecution agreements. And there are set out there very helpfully in detail a number of key factors which will influence the success or otherwise of your ability to obtain such an agreement. Not surprisingly, one of those is credibility. You've got to engage early, not put your head in the sand. You've got to have an internal investigation that is independent, that covers all the areas, that doesn't just try and present a certain type or extent of what's gone on. You do need to come up with new information that the SFO or the other authority won't know already. Acting within that reasonable time frame, being prepared to engage in any remedial action that is discussed or that you've decided upon, helping to identify witnesses who may help the SFO, showing the SFO your past record, that you've never engaged in this sort of alleged behaviour before, helping to identify perhaps, if there has been a difficulty, those individuals, perhaps rogue individuals within your company who ultimately were responsible for the behaviour involved. All these things, as well as during that negotiation showing the impact that this prosecution would have upon you as a company, but all these things together are likely to improve your chances significantly of avoiding the ultimate sanction here, which would be a prosecution, a public prosecution in a Crown Court.
Well, thank you very much. I appreciate that would have covered all of the issues on a very broad area, in a very complex area. But that's a great introduction. And thank you very much for your time.
Not at all, thank you.